Good afternoon. Before I start to talk about the licensing conditions one by one, I would like to remind you that under the Moneylenders Ordinance, no person shall carry on business as a moneylender without a license granted under Section 11 of the Ordinance. A license shall be subject to the conditions imposed by the licensing court. If the licensing court considers that the licensee has been in serious breach of any conditions of the license, the court may order to revoke or suspend the license. According to licensing condition number 1, before entering into any agreement for loan, the moneylender shall ask the intending borrower to state in writing whether or not he has entered into or signed any agreement with any third party for or in relation to the procuring, negotiation, obtaining, or application of the loan, or guaranteeing or securing the repayment of the loan. If the answer is yes, the moneylender shall state in writing in the loan agreement the name and address of the third party, and whether the moneylender is in any way related to the third party and the nature of such relationship. This written information is prepared by the moneylender. The moneylender shall also ask the intending borrower to personally provide a copy of the third party agreement, and also attach the third party agreement to the loan agreement. Unless the third party has been appointed by the moneylender as third party and has confirmed in writing to the moneylender that he has not charged and will not charge any fees, however named, from the intending borrower, and has not otherwise agreed with the intending borrower that the intending borrower pays or would pay any fees, however named, to any other party, whether for the purchase of any goods or services or not. Otherwise, the moneylender shall not grant any loan to the intending borrower. Under licensing condition 3, the moneylender shall provide in writing to the satisfaction of the Commissioner of Police and the Registrar of Moneylenders the name, address, and identification number of the appointed third party. The third party is not considered as an appointed third party until after the name and address of the appointed third party appear on the register kept by the Registrar of Moneylenders. The list of appointed third parties can be found from the company's registry's website. Under licensing condition number 4, the moneylender shall not knowingly allow or permit any person to charge, recover, demand, or receive any fees, however named, from any borrower or intending borrower. For example, the purchase of goods or services or charging, processing, or administrative fee. The term any person includes the moneylender or his partner, employer, employee, principal or agent, or any person acting for him or any appointed third party. According to licensing condition 5, before entering into any agreement for loan, the moneylender must give explanation to the intending borrower of all the terms of the agreement, in particular, the interest rate expressed as a rate % per annum and the total amount of the interest payable, the amount of repayments periodically and in total under the agreement, the possible consequences for any default in repayment, including the taking into possession and sale of any security involved, and any overriding right of the moneylender to demand an immediate repayment. The moneylender must keep written or video or audio records which show that he complies with the requirements under this condition. I would like to remind you 2 points regarding the licensing condition 5. First, moneylenders should clearly explain to the intending borrower all the terms and conditions of the loan agreements. Second, licensing condition 5 covers all kinds of moneylenders, including the moneylenders who establish business relationship with borrowers by a non-face-to-face approach and keep records in video or audio form. Under licensing condition 6, the moneylender shall not obtain or collect personal data of any person from another person or use such personal data which are obtained or collected from another person for the purpose of or in relation to the moneylender's business if either one of the following conditions is not fulfilled. One of the conditions is the moneylender does not get the written confirmation from that other person that the disclosure or provision of such personal data by that other person for use of the moneylender is not in breach of the Personal Data Privacy Ordinance. The other condition is when the moneylender has knowledge or has reasonable grounds to believe that the disclosure or provision of the personal data by that other person for such use of the moneylender is likely to be in breach of the Personal Data Privacy Ordinance. Besides, the moneylender must keep records which show that he complies with this requirement and the provision of the Personal Data Privacy Ordinance. According to licensing condition 7, the moneylender shall not accept a subsidized flat provided by the Hong Kong Housing Authority as collateral for the loan unless the borrower has produced to the moneylender a written confirmation from the Hong Kong Housing Authority that the necessary premium for removing the restrictions on alienation on the said flat has been fully paid, or the written approval of the Director of Housing granting approval to mortgage or charge the said flat. According to licensing condition 8, the Chinese version of any advertisement issued or published by the moneylender for the purpose of the moneylender's business as a moneylender must clearly show the Chinese character, that is this one, and immediately followed by the number of the moneylender's license. According to licensing condition number 9, any advertisement in relation to the money lending business, which in textual, audio, or visual form must be fair and reasonable, and not contain misleading information, and contain a moneylender's telephone hotline for handling complaints, and a risk warning statement. That is this one. This is the risk warning statement. The risk warning statement must be in the same language as that of the advertisement or a relevant part thereof, and clearly audible in the audio part of the advertisement. To ensure that the advertisement is fair and reasonable and does not contain misleading information, the advertisement must not contain information that is misleading or deceiving, must not emphasize any potential benefits of a product or service without also giving a fair and prominent indication of any relevant risks, must not discuss, omit, diminish, or obscure any relevant fact which will result in the information or message being insufficient, unclear, unfair, or misleading. Any important information must be in conspicuous text and placed in a conspicuous position in the advertisement. The advertisement should not carry information that understates the cost of borrowing and overstates the ease of borrowing. For the displays of or broadcast of risk warning statement for advertisement, in the in the print, the advertisement should be displayed in text in at least 50% of the font size and in the same font type and color as the other contents of the advertisement that bear the largest font size. For the displays or broadcast or risk warning statement, in the audio-visual advertisement, the advertisement should be in clear contrast in color with the background or backdrop of the advertisement. Where it appears in an independent screenshot, it should be displayed visually at the end of the advertisement for at least 3 seconds with a clear readout for the same duration. Where it appears throughout the entire advertisement, it should be shown clearly at the bottom of the screen. The height of each Chinese character of the statement be at least 1/15 of the screen. The height of the capital letters of the English statement be at least 1/20th of the screen, with a clear readout in the same pace as other contents of the advertisement. Regarding the licensing conditions number 8 and 9, I have 5 points for you to pay special attention to. The first point is that advertisements related to money lending business, including all kinds of publicity materials, shall comply with licensing conditions 8 and 9. Secondly, please ensure to display the valid moneylender's license number in the advertisements. Thirdly, the advertisement must contain a complaint hotline. Please note that application hotline or inquiry hotline is not equivalent to complaint hotline. Fourthly, the name of the moneylender as specified in the license, not just the business name, must be shown in the money lending advertisements. This is a requirement by the Section 26 of the Moneylenders Ordinance. Lastly, if an advertisement states that certain loans are interest-free, 0% interest, etc., it will give the impression that there are no interest or monthly fees. If a monthly administrative or handling fee is charged, the advertisement would be misleading. According to licensing condition 10, the moneylender and his debt collectors shall not try to recover debt, whether directly or indirectly, from anyone, for example, the referees, borrowers, family members, or friends, unless such person is in law indebted to him. They shall also not to harass anyone, adopt unlawful or improper debt collection practices. The moneylender himself shall ensure personal data collected are protected against unauthorized or accidental access, processing, erasure, or other use by any debt collectors, shall comply with the Personal Data Privacy Ordinance, shall maintain and monitor proper systems and procedures for handling complaints and/or inquiries relating to the loans lent by him in the ordinary course of business and the debt collection activities arising therefrom, shall keep updated and accurate records of the debt collection activities of his debt collectors during the term of the license. Moneylender must clearly understand that whether the debt collectors comply with the law and the relevant requirements under licensing condition 10 in his debt collection activities is a factor for determination of whether the moneylender is a fit and proper person to carry on business as a moneylender. Moneylenders must exercise proper care and diligence to monitor the debt collection activities of their debt collectors. Debt collectors should not be given a free hand as to debt recovery procedures. According to licensing condition 11, the moneylender shall provide information relating to his moneylending business during the term of the license, as may be required by the Registrar of Moneylenders or the Commissioner of Police within such time as specified. For example, to join the moneylender sessions annual exercise for collection of financial information and thematic surveys in which moneylenders are required to participate. Under licensing condition 12, the moneylender must establish and maintain proper systems and procedures to ensure that the parties on the right side shall be informed of and observe the licensing conditions and the provisions of the moneylenders ordinance. The parties concerned are the moneylender or his partners, employers, employees, principals or agents, persons acting for him, and the appointed third parties. The proper systems and procedures, what I have said, include the management and supervision, personnel and training, review of appointed third parties, and the record keeping. Under licensing condition 13, where any referee is provided in respect of the loan application, the moneylender shall, before entering into any agreement for loan, ask the intending borrower to provide the written consent signed by the referees, confirming his or her agreement to act as referee in respect of the loan application, and attach the written consent to the loan agreement. If the moneylender is informed or aware that the written consent was in fact not signed by the referee, the moneylender shall immediately cease to use the information of the referee. Referee is the person who provides, on a voluntary basis and upon request by the moneylender, information about the intending borrower in respect of the loan application. For example, for identification purpose of the intending borrower before entering into the loan agreement. You must note that referee is not for debt collection or for contacting the borrower after the loan agreement has been entered into. Regarding licensing condition 14, the moneylender must comply with the guideline on compliance of anti-money laundering and counter-terrorist financing requirements for licensed moneylenders, and assess the money laundering or terrorist financing risks of their businesses, develop and implement policy, procedures, and controls in 7 aspects. That is, risk assessment, customer due diligence measures, ongoing monitoring of customers, suspicious transactions reporting, record keeping, staff training, and independent audit function. You can download the guideline from our website. Now we come to the last licensing condition, that is licensing condition 15. Before entering into the agreement for or before granting any significant increase in the amount of loan under an agreement for unsecured personal loan, the moneylender shall undertake an assessment of the intending borrower's or borrower's ability to make repayments under the loan agreement affordably and have due regard to the outcome of the assessment in respect of the affordability. In carrying out the assessment, the moneylender shall consider the intending borrower's or borrower's current income and expenditure, and the ability to make repayments under the loan agreement as they fall due over the life of the loan agreement, without having to borrow to meet the repayments, and without the repayments having a significant adverse impact on the overall financial situation. Regarding the need for the assessment to be reasonable, the moneylender must base the affordability assessment on sufficient information available to him at the time of conducting the assessment. The extent and scope of the assessment, the steps that the moneylender must take, and the evidence to be taken into account are dependent upon and proportionate to the individual circumstances of each case. the moneylender should adopt a common sense approach and decide what is appropriate and proportionate to the circumstances of a particular case. When making the assessment, the moneylender should consider the following factors. They are the total amount of the principal and interest payable, the duration of the term for repayment of the loan, the frequency and amount of the repayments, the interest rate, the purpose of obtaining the loan, the employment or business of the intending borrower or borrower, current credit and financial information on the intending borrower or borrower, and any other potential adverse consequences for the intending borrower or borrower arising under the loan agreement from a failure to make a repayment by the due date. As to the current income and expenditure, moneylender must take reasonable steps to determine the amount or make a reasonable estimate of the current income and expenditure of the intending borrower or borrower. When considering the current income, the moneylender should take into account the salary. The moneylender can also consider the other income, such as the dividend and rental income of the borrower. When considering the current expenditure, the moneylender should consider the existing debt and the essential living expenses and other expenditure which is hard to reduce to give a basic quality of life. Moneylender may also consider the savings and assets of the borrower. Besides, when it is reasonably foreseeable that there is likely to be a reduction in the income or an increase in the expenditure, which could have a material impact on the ability to make repayment affordably, and without the repayment still significantly affecting their overall financial situation, the moneylender must take reasonable steps to estimate the amount of debt reduction or increase and take it into account in the assessment. Lastly, the moneylender must also keep the written or video or audio records which show that the requirements under this condition have been complied with. Regarding licensing condition 15, we have 4 points for moneylenders to pay attention to. First, self-declaration of income and expenditure by the borrower or intending borrower is not an affordability assessment. The moneylender must base the assessment on sufficient information available with evidence to show the assessments carried out by the moneylender, for example, by signing and dating the written assessment. Second, assessment record must show the factors that the moneylender has considered, especially the special factors. Thirdly, the moneylender must ensure the information shown in the assessment matches the information provided by the intending borrower or borrower. Lastly, the moneylender should adopt a common sense approach and decide the reasonableness of the information provided by the intending borrower or borrower. The moneylender should require the intending borrower or borrower to provide relevant supporting documents, if appropriate, and keep copies of the supporting documents. Our company's registry has issued the 2 main guidelines. They are the guidelines on licensing condition of moneylenders' license and the guideline on compliance of anti-money laundering and counter-terrorist financing requirements for licensed moneylenders. The first guidelines contain the annexes, which provide many samples of the documents which the moneylender is required to prepare. The other guidelines include the guideline on fit and proper criteria for licensing of moneylenders and guideline on submission of business plan by applicants of moneylenders license are also available. All these guidelines can be downloaded from our Company Registry's website. If you have any inquiry, you may also call our hotline or send an email to us. My part on the licensing conditions has finished. Thank you.